207 DT versus Rich. Counsel, do you like some rebuttal time?
Yes, 1 minute, Your Honor.
Okay, go ahead.
May it please the Court, my name is Derek Spada, and I represent DT. The lower court should be reversed because there are questions of fact.
What are the questions of fact, Counsel?
Your Honor, the questions of fact, firstly, are whether respondents' policies and protocols were reasonable, and if so, whether their haphazard actions on this unfortunate evening were reasonable and prudent or not.
Can this kind of issue be a question of law?
Sometimes, but not here. I mean, in certain...
Your argument is that it rarely is in this kind of situation?
Very rarely. I mean, firstly, it's negligence, which is rarely an issue for summary judgment. Secondly, it pertains to foreseeability and reasonableness, as the dissent laid out. Those are classic jury issues, not issues to be resolved as a matter of law. And in this case, they should not have been resolved as a matter of law.
So what was wrong with the protocol? I mean, you obviously, if there's a dispute about it, it's for a jury. But tell your side of the dispute. What's wrong with the protocol?
Sure, Your Honor. With the protocol, there's no written policies or procedures in the record. There's very little to go on as to what the policies and procedures really were. But as explained by Ms. Mildred in her deposition testimony at pages 201 through 202, she explains that when, not if, but when a resident escapes and goes out onto Route 9W, they're supposed to just follow them and give them distance so as not to aggravate them.
They're not supposed to. That's really all we know, is that there's a rule they're not supposed to touch them.
Well, Your Honor, but then there's more to it. At pages 157 and 158 in the record in Ms. Meyer's testimony, she also talks about once de-escalation fails, then they have to restrain a resident. So Part A of the protocol seems to be de-escalation through talking, through non-physical means, and then when de-escalation fails, then they have to physically intervene. In this case, they took like this middle route of corralling DT on Route 9W. It was just a...
Is that the aspect that you're focusing on, was when the child is on the highway, or is it also her leaving the facility to begin with? I'm trying to determine, is there more than one aspect of this sequence that you find that isn't deserving of summary judgment, or is it just when they actually find her on Route 9?
Your Honor, firstly, in the manner in which DT escaped, it was about 10 o'clock at night. She had a coat on, so there was some notice she was about to leave when she put her coat on, but no one saw that. She escaped through a door.
It's both.
And it's both. It's both. And she escaped through a door.
So it's the whole scenario.
The whole sequence of events from when she put her coat on to when she got hit.
They did have quite a few employees looking for her. It isn't as if one person just walked around the grounds.
Right. There were at least 4. And when she escaped through a door that should have had an alarm on it. It seems she went out through a fire door, but the alarm was turned off, or the front door, which should have been locked and wasn't. So there was some negligence in letting her out of the facility.
How much time elapsed from when she left and when they found her?
From when she left until when they found her isn't precisely clear, but it's somewhere. Well, the whole event is about 35 minutes.
I was going to say, it seemed like less than 40 minutes.
Yes. The whole time from when she left until when she got hit is 35 minutes. Because she left at 10 p.m., and the police accident report says the collision was at 10:35.
So there are various critical points, is what you're arguing, from in those 40 minutes, that there are different issues of fact raised?
All along the way. All along the way. And at first, once they realized that she was out, one employee went out. And then that was Miss Boleyn. And then she brought her cell phone, couldn't find DT, called back, and then someone else came out. And then
slow down a bit. Can you point to, you say there are a lot, but is there one particular moment where you can say one person did something wrong?
One person individually who did something wrong, I would say yes. I can't name the person because I don't know who did what precisely as the events unfolded, but I will say firstly the person who failed to ensure that those doors were alarmed did something wrong. Secondly, the person who failed to ensure that their front door was locked did something wrong. Thirdly, the person who failed to notice DT with her coat on did something wrong.
You say it's negligence not to have the kids locked in?
Not necessarily locked in, but have the doors alarmed at least. So if someone goes out, an alarm will sound and they'll catch it right away.
She didn't slip out unnoticed. They knew she went out, right?
There's a group of them that left, right? Did I misunderstand the record?
I believe it was just one on this evening, Your Honor. In the past, other people left. And DT left other facilities before being placed at Respondent's facility, of which Respondent had notice. And Respondent also had noticed that DT escaped from this facility a couple of times. That's explained at 158 in the record in Ms. Meyer's testimony.
I'm going back to the alarm, though. I'm having trouble with what As I understand it, so one of the people saw her leave and followed her.
It's not clear as to whether she saw her leave or whether she went out after her once she realized she was missing. So from the testimony, it's, I don't believe it's clear.
If you assume it's the former, though, then the alarm doesn't matter. I mean, if you see somebody leaving, I don't care whether there's no siren or not.
Sure, that's a good point, Your Honor, yes.
I'd like to go back to something Judge Graffio asked you about the scope of what you're complaining about, because there was a lot of information about the child's mental state. Are you also talking about some sort of notice to the facility that she might have been depressed or in some other way susceptible to leaving the facility and had some other problems that they needed to be aware of while she was on the road?
Yes. She had some suicidal tendencies.
Suicidal?
Well, she made threats on cutting herself.
Is that suicidal?
Well, it's not. I would say it's not normal.
Mutilation. Does that mean it's suicidal?
I would say it could be viewed that way. Not necessarily. I mean, she never said she was going to definitely kill herself, but making threats on cutting oneself is not normal.
Well, are you saying that a home like this can be found negligent if a child is threatening to cut herself by not isolating her, putting her on suicide watch, putting extra guard on her? What are they supposed to do?
What they're supposed to do, Your Honor, is, what they're supposed to do is at least have these doors alarmed or pay attention to the residents more closely, especially when there's a history of residents and this particular resident escaping from this facility. But the negligence that happened, I'd say the most glaring negligence occurred when they were out there on the roadway.
What's the standard of care? What's the standard of care? The
standard of care, Your Honor, has not, I would say based on the legal precedent, it's not yet been set. The standard of care in this case.
Do you want a standard of care that's equivalent to a mental health facility?
I would say it's not quite like a psychiatric institution because it's different than a psychiatric.
This is certainly not a psychiatric
institution. It's
not,
Your Honor. That's correct. But it's also not an ordinary parent's house or an ordinary school.
So it's in between.
It's in between in the gray area. Yes. Yeah, so it's a more stringent standard than a reasonably.
What about if we think it's just a reasonable parent standard? You still have an issue to go to the jury?
Absolutely, because with that standard, Your Honor, then the negligence pertains primarily to what really occurred on the roadway, and the question is it reasonable and prudent for a parent or teacher or adult, or several adults here in this case, to use a vehicle and corral a 13-year-old troubled youth on the middle of Route 9W on a rainy and foggy night while she's wearing a dark-colored coat?
What standard did you argue to the jury?
We didn't get there. It was summary judgment where we got dismissed.
I'm sorry, this is summary judgment. What standard did you submit to the court?
The standard that I submitted, was more toward a psychiatric institution.
It was more heightened.
More heightened.
The paper said more heightened. A request for a heightened standard.
Yeah. And in the lower court, in Supreme Court, the issue wasn't raised by respondent as to the standard, and so the standard isn't in my original papers, but then it's raised by Supreme Court in the decision. It was a sua sponte topic that was raised in the lower court. So the standard, it's out there to be ruled upon if you choose so.
And that's the reasonable parent standard. That's the standard. That's the standard the Supreme Court.
Yes, that's the standard that the Supreme Court found. But under these facts in this case, it should be a heightened standard based on the history. And under any standard,
going back to the roadway, can you be a little more specific? Who did what that was wrong while they were on the roadway?
There were 4 or possibly 5 employees out there. One had a car, and as they followed her, one passed her with the car and tried to box her in. And going back to the policies and procedures of respondent that are outlined in the testimony of Miss Meyer, they didn't give her space, obviously, because they were right on her trying to whatever. I don't know what they were doing. But no one tried.
You're also complaining they didn't follow it?
They didn't follow it, and no one tried to grab her. And she was on the roadway for up to 5 minutes.
Could a jury really find on this record that it was negligent not to try to grab her? I mean, isn't that obviously the sort of thing when a kid is in that situation of this horrible choice? Do I grab her and maybe she'll run into the traffic, or do I try to calm her and talk her down?
Your Honor, the jury could absolutely find that there's negligence based on their failure to attempt to grab her when there's 4 adults, if not more,
that attempted to grab her and she was hurt, you'd be suing because they did it.
I don't think I would have a case under those circumstances if she was injured while being taken off the roadway for her own safety. In this case, they corralled her on the road.
What if they tried to grab her and she ran away and ran in front of a car?
Well, when there's 4 adults out there, one of them should have been able to grab her, and that's part of respondent's procedures.
You're almost saying race to Lockwood her, aren't you? You're saying that for this kid to get away from 4 adults, that couldn't happen without negligence.
Basically, yes. Yes. And
I'm sorry.
Go ahead.
Finish. I'm sorry.
No.
Did they call law enforcement? Did they advise anyone that she had escaped?
They never called the police. They never called
Ask anyone to close the road?
No.
Okay, counsel. You'll have your rebuttal.
May it please the Court, I'm Barbara Goldberg. I represent the St. Cabrini home.
Counsel, why aren't there issues of fact here? There seems a lot of gray areas as to what they should have or shouldn't have done.
Your Honor,
Why even using a reasonable parent test? Why isn't this the kind of case that should almost invariably go to a jury rather than be decided as a matter of law?
Your Honor, I respectfully disagree with that because
There are no gray areas?
I don't think there are any gray areas because
They did everything right in terms of the child getting out from the home. They did everything right on the road. That's clear and unmistakable as a matter of law?
Your Honor, if I can just go back a little bit, I believe
No, but answer my question.
Yes, I'm going to answer your question. I don't think that there are any gray areas because what Mr. Spada would characterize as gray areas are...
Take us through what happened here and explain why there's no gray
All right,
area.
I will be very happy to do that, Your Honor. It was about 10 o'clock at night. The girls in Cottage 1, of which D.T. was a resident, were getting ready for bed. It was 10 o'clock. D.T. suddenly and unexpectedly ran out of the residence. She was noticed by Miss Boland, who followed her, said she was going after her. Miss Meyer, who was present at the time, said, give us a call if you need help. Now, the evidence is clear that this was an unlocked facility. Plaintiff put in no proof that the doors of this facility were required to be locked from the inside at night or at any other time. There's just no proof in that.
What about the girl's own testimony? Her recollection was that they were locked. She was usually locked in, but that night she got out somehow?
Your Honor, again, whether I've said that even if there's an issue in that regard, it's not an issue of fact that requires sending the case to
It's not a material issue.
the jury. It is not a material
Were there alarms on the doors of the
According
cottage?
to Ms. Meyer's testimony, there were alarms on 2 fire doors. It's not clear that there was an alarm on the front door, but again, as was mentioned previously, the record indicates that Ms. Boland noticed my reading of the record is that Ms. Boland noticed her as she was leaving the residence, followed after her immediately. She called back and said that she couldn't find her. They called Mr. Bellino, who was the administrator on duty. That was well within the protocol as established by Ms. Oliver's affidavit.
Are the protocols written, counsel?
I'm sorry?
Are the protocols written? This was all testimony, right? Are there written protocols that one could look at?
Your Honor, it's not clear from the record whether the protocols were written or not, but Ms.
Well, do you know that? As their lawyer, can you tell us whether or not they have written protocols? Have you ever seen written protocols?
I personally have not seen the written protocols.
Are they regulatory or
Well, there are
summary judgment motion? Were there any regs that were attached?
Yes, there are. Well, I think the court can take judicial notice of the regs. Ms. Oliver stated in her affidavit that the staff to resident ratio in the cottages actually exceeded what was required by the regulations. The regulations require 1 staff person for each 8 residents.
I'm not mentioning staffing. I'm referring more to what to do when one of the inhabitants leaves the facility.
In my research, I didn't find any regulations that dealt with that, Your Honor. However, I did find a regulation that said that it's not permissible to keep a child in a locked room. I'm not aware of any regulations dealing with what to do in a situation.
So is it hard for us to answer whether, as a matter of law, everything was done properly when we don't even know what the protocols are?
Well, Your Honor, we do know what the protocols are because
how do we know that?
We know that from the affidavit that Ms. Oliver submitted, and we know that from Ms. Meyer's testimony.
And we have the affidavit of the victim, right?
Well, we don't have an affidavit from the plaintiff. We have the deposition testimony.
Deposition.
The deposition testimony of the plaintiff.
So that doesn't raise any issues?
That doesn't raise any issues because the protocol was that you use therapeutic crisis intervention, you use de-escalation techniques.
What is de-escalation?
De-escalation techniques, as explained by Ms. Meyer, is that you try to talk to someone, you try to calm them down, you try to get them out of the potentially dangerous situation.
And is it the same protocol if you already have had an experience where the same individual has escaped and has a history of escaping? Is it the same protocol?
Your Honor, I disagree with the use of the word escape, because, and I think that's an attempt to exaggerate what went on here. The testimony in the record is that she had left the cottage on 1 or 2 prior occasions, and on those 2 occasions, staff members saw her, said, come back, she came back, there was never any incident. There's not a repeated history of this person trying to pull them.
Well, then why did Ms. Meyer say that she knew that the plaintiff needed to be watched and needed a lot of guidance because she'd left before?
The reference there is that she had AWOL'd, A-W-O-L'd, on a couple of occasions from
right.
a
You want to call
previous
it, there's elopement, there's escape, but now there's away without leave?
Well, it's not my terminology, Your Honor. It's the terminology that's in the record. But my point is that none of these prior episodes, and we actually have very little detail about them in the record, none of the prior episodes was such as to put them on notice.
See,
that
that's
she was
what
at
you
risk.
say. There's a lot of conclusions here, like the Oliver who talked about de-escalation. I thought, what in the world is de-escalation? And you say, well, you just talk to them.
That's what she said.
If I was a parent and my daughter was out in the middle of the night running away, I'd call the cops. And that didn't happen here. And the police have lights and sirens, and they have abilities to find people and to command some presence. And that apparently wasn't done. Now, I don't know if that's a basis in this case or not, but I didn't see particularly what Cabrini did that even matched close to that.
Well, I think that what Cabrini did, even before I get to what Cabrini did, Your Honor, I think that on this record it's pure speculation as to what would have happened if the police had been called, if she wouldn't go into the staff vehicle when that came up.
That's why summary judgment is so difficult.
But, Your Honor, summary judgment, it is very well established. The Court has said many times that issues of fact have to be more than speculation. They have to be more than
but you're asking us to grant, as a matter of law, based on what you say. If I say I took every precaution and I treated this situation perfectly, so then summary judgment, because we just accept that you're right, when again I come back to what I said to you originally. At every step of the way, there seems to be gray areas that would raise to anyone's mind as to whether the home acted properly. Why is that such a difficult concept? Does it have to be we say it, we're not telling you what our protocols are, but we've been trained in whatever it is, and we did it right? That can't be enough.
Your Honor, it is enough because at each level we established that we had more than sufficient staffing. We established that we had
you had a staffer who said, I was directed, I could not grab her. I can't touch her. Does that make sense when you've got a person out in the middle of the night on the dark road?
Your Honor, I think it does make sense because
could reasonable minds disagree with respect to that?
You don't know what's going to happen. It's pure speculation.
Well, how did I'm having trouble understanding how 4 adults are out on this roadway for what, almost 10 minutes, and no one can put this child back in the car?
Your Honor, she was actually in the road as opposed to being on the
I don't understand what the aim of the protocol is if it isn't to preserve the
They
safety of the
were trying to talk to her. On each time that she went across the road, a staff member followed her, and the staff member.
But maybe someone could believe that their actions were negligent in the decisions that they made. That's all. I think the line of questioning that you've been getting just now is just, we understand what your position is. But as Judge Pickett said before, couldn't reasonable people see this differently as to whether the home was negligent in what they did or whether they acted perfectly, as you say, and did it just right? Why is this such a difficult concept?
Your Honor, there was no proof put in by the plaintiff in opposition to the motion as to what should have been done differently. They didn't.
Only because their position is that you have not established your entitlement to judgment as a matter of law.
But I think the safer thing to do, Your Honor, would have been to put in proof from a social worker, this is what an acceptable protocol is.
But there's a burden here that has to be met, right, to get
and
summary judgment.
I think that we met that, Your Honor, because
What do you think is the standard that should be used here, counsel?
I think the standard of care here is the standard that the Supreme Court and both the majority and the dissent at the appellate division applied. That's the standard of the reasonably prudent parent. And in order to raise issues of fact, the plaintiff would have to show that a parent in the exact same situation would invariably have done something different. And I don't think that
Does he have a burden if you haven't met yours?
Your Honor, the case law is very well established. I have to concede that if the movement doesn't make out a prima facie entitlement to summary judgment, then the burden never shifts. But I submit that here we did, and the burden did shift.
Okay, counsel. Let's hear a rebuttal from your adversary. Counsel.
Thank you. The questions here that you've asked throughout this argument are really, it's really a fact-based issue here. There's, there's issues of law as well, but there's lots of issues of fact in this case.
I guess what's bothering me is, can it ever happen that a child in the care of a facility like this is injured and the case doesn't get to a jury?
It could happen, but, under certain circumstances, it could happen, Your Honor. But under these circumstances,
you have to meet the burden of proving that everything you did was perfect. Can anybody ever meet that burden?
They could have met the burden if they submitted their protocols, perhaps if they had an expert to reinforce the.
Well, in an odd way, if they had said that the doors are unlocked and we didn't know that she was missing, and therefore we never pursued her.
In that case, it could go back to whether the door should have been locked or alarmed, and they may have missed her going out. Then that's a possibility, but that's more of a stretch. In this case,
But aren't they inevitably just making discretionary decisions that reasonable minds could differ over? But does that mean it's negligent?
That's for a jury to resolve whether it's negligent. There's issues here that people can differ over. But
we've talked about if they had pursued her across the, she might have been chased into traffic if they tried to approach her. I mean, you never know. You don't know. Didn't they make? Isn't that what aren't we really second guessing discretionary decisions?
No, Your Honor. What they did here in this case was about the worst possible thing they could have done. They corralled her on the highway. If they just let her go and followed Plan A in de-escalation, where Ms. Meyer testified, they just followed them in a safe distance.
That's clear. That would be clear.
Well, that would be at least comport.
That's what you're going to prove to the jury.
Well, that would at least comport with their protocols. Now, whether those protocols are reasonable is Part B of that issue, but Part A is that's their. That's if a jury accepts their purported protocols, then a jury could find that they should have done that.
Okay.
Thank you.
Thank you both.